Hello, this is Cynthia Ho from Loyola University Chicago School of Law. I'm just going to give a quick overview about access to medicine issues, mostly under WTO TRIPS and beyond. So a quick outline of what I'm going to talk about. I'm going to first start with some basic introduction to patents, for those of you who are not familiar. Then I'm going to focus on the international framework, basically the WTO TRIPS agreement, and what flexibilities exist under that to promote access to medicine. And then I'm going to highlight some issues about compulsory licenses, which have been very controversial. And I'm going to end with some possible TRIPS plus issues on the horizon. So to start with, what is a patent? A patent is basically something that a nation grants, and generally it provides the owner of the patent the right to exclude all others from making, using, selling, or importing the patented invention. It's not actually a right to use the invention. It's possible that somebody else owns a patent that prevents you from using your invention if you have an improvement, or it's possible that you have a patent on a drug for which you're not allowed to sell it without getting prior approval. Now, patents are very important to companies because even though it's not an absolute right to use, it is a powerful right in the marketplace if no one else is allowed to make the same thing you're doing and there is some commercial advantage. But patents are limited in time and geography. Patents generally last less than 20 years, and a patent is only valid within the country that grants the patent. So for companies that want global patent protection, they have to apply in every single country where they want protection. In addition, since patents are national, that means each country may or may not grant the patent, even if the company wants it. Now, TRIPS does require all countries to have certain minimum patent requirements, but it's not uniform, the laws, as we'll talk about. So a company still may not have uniform patent protection despite its best efforts to apply worldwide. Another important issue about patents is that they're basically one size fits all. In most countries, all inventions that are patentable get the same patent term, even if it's a minor trivial invention or a major breakthrough. Generally, all patents get the same term. There are people who talk about whether or not that's a good idea, but that is just how it currently is. So a little background as to how you get patents. Basically, you have to apply. It's not automatic, and you have to meet the requirements of the country that sets it forth. And the people who examine patents are basically people with technical backgrounds that can competently evaluate whether the patented application meets the requirements, usually of being new and having an inventive step. Now, you may be wondering why we have patents. There's some general policy about having patents to promote new inventions which benefit the social welfare, but not all new socially positive inventions are the result of patents. In fact, there are some very notable patents that are not, or rather not notable patents, but notable inventions that are not patented. For example, Dr. Salk, the creator of the polio vaccine, did not patent his invention, and when asked why not, he said, well, can you patent the sun? He thought that something as important to society as a polio vaccine should not be patented. You might also think about the history of patents. Historically, a long time ago, in the 1700s, patents were considered a privilege granted by the crown. In addition to being a privilege, they were considered a tool to try to promote and transfer technology to the local economy. So basically, creators of new inventions were given a patent but required to make and use their patented invention locally so that the local people would then know how to use and make the patented invention and be able to use that. Also, historically, many countries did not provide patents on drugs. As late as the early 1900s, there were some European countries like Spain and Portugal that did not patent drugs. In addition, India, until it complied with TRIPS, did not provide patents on drugs, only methods of making drugs, in an effort to maximize the number of new drugs that were created by different methods and ensure that drugs were provided at low cost. In addition, many countries had local working requirements and issued compulsory licenses on drugs to promote low cost drugs. Now, there obviously are some issues about compulsory licenses under TRIPS, but this is all by way of background as to the fact that historically there has been strong recognition that even if you grant patents, there should be flexibility in some situations to promote other social interests such as access to drugs. Now, under our current society and current laws, patents are basically a business reality. And even in countries that were not so enamored of patent protection, they are a reality under WTO TRIPS. Basically, all countries that are members of TRIPS, except least developed countries, must provide patents on drugs. That's part of what TRIPS says, and TRIPS is an international agreement that has teeth in that it's very enforceable. There are strong sanctions if you fail to comply with TRIPS. So basically, what's under TRIPS does have to be complied with, but there are some current flexibilities. Now, on the left are some basic requirements under TRIPS, and on the right, there are some flexibilities. So we're going to look and compare the requirements versus the flexibilities. So the basic requirement of TRIPS is that you have to have patents on all inventions, although what is an invention is not actually defined. So, for example, some countries might consider software not to be an invention. Also, it says patents have to be on all inventions that meet requirements. And under TRIPS, some of those requirements are that the invention be new and that it have an inventive step. But importantly, those terms, like what is new, is not defined. So new is an ambiguous term that permits countries to define it on its own. So importantly, India has taken some innovative steps to define new, saying that if you have a composition that is perhaps a minor variation of an existing drug, a new salt or isomer, then maybe that isn't really new unless there is improved efficacy. Now, this part of India's patent law, Section 3D of India's patent law, was used to deny a patent on Novartis's Gleevec cancer drug. This case is before the Supreme Court of India currently to be heard in November 2012, but this is an important part of India's patent law that gives it flexibility. Additionally, although TRIPS requires that patents be granted a minimum term of 20 years from the date the patent was filed, there is no requirement to grant an extension on this term if the patent takes a long time to be issued. Despite some proposals during the TRIPS negotiation, this is not part of the TRIPS requirement. So countries like India do not have to grant a patent term extension, even though other countries like the US do grant patent term extensions. Also, TRIPS requires compulsory licenses under certain rules, but countries do have flexibilities to grant compulsory licenses, as we'll talk about shortly. In addition, although TRIPS requires that patent remedies be provided, there are flexibilities in that although countries have to permit the ability to provide permanent injunctions, it doesn't actually say when those permanent injunctions have to be granted to a successful plaintiff that wins in a patent infringement suit. So currently, unless a nation has complied with other agreements beyond TRIPS, nations would have the discretion to permit their national courts to deny a permanent injunction even to a prevailing patent owner. TRIPS also requires some kind of protection for data that is provided to regulatory authorities, but it's a little ambiguous whether or not patent owners who have such protection can preclude subsequent generic manufacturers from relying upon that data. It's a major issue of concern. The last flexibility is something that's not mentioned in TRIPS at all, and that has to do with who can object to patent applications or possibly issue patents, what's commonly called oppositions. So some countries like India have both pre-grant and post-grant oppositions, abilities for non-government organizations, patient advocacy groups to oppose a patent application as perhaps not novel, or maybe oppose a patent application as not having an inventive step. This has been used very successfully in India in both pre-grant and post-grant oppositions to challenge and revoke patents. Now, moving on, compulsory licenses are a major issue under TRIPS. And TRIPS continues to permit compulsory license to be granted, but there are additional requirements. One important thing is that compulsory licenses have to be based on the individual merits. What this means is a country can't grant blanket licenses on all drugs. The country has to look at individual patents and decide in an individual case whether or not to grant the patent. Also, there have to generally be prior negotiations. This goes with the blanket compulsory licenses being banned. So generally, the patent owner has to be asked permission, although there are some important exceptions that we'll talk about. There are a number of other requirements, and always the patent owner has to be given adequate remuneration, although what that is not actually clearly defined under TRIPS. There also has to be review of the compulsory license authorization and remuneration, but this review is domestic. There is no WTO body that must review whether or not the compulsory license is permissible. The compulsory license generally also has to be for domestic use. There is a very important exception, a complicated exception that permits domestic, or rather compulsory licenses for export to very poor countries, which I'm not going to get into today. But generally, compulsory licenses have to be for domestic use and subject to termination if they are no longer necessary. Now let's talk about some key issues that need to be clarified. One common misperception is that compulsory licenses are not allowed. That's totally false. They are permitted, but TRIPS does not govern all political consequences. And indeed, when Thailand issued a number of compulsory licenses back in 2006, 7, and 8, Abbott pharmaceutical companies took the dramatic action of withdrawing certain drugs from the approval process. Importantly, it withdrew initially the antiretroviral Kaletra, which is designed especially for humid environments like Thailand. After huge public protests, it changed course on that, but still, that highlights that although there is authority to grant compulsory licenses, that does not immunize countries from political consequences. Another common misperception is that compulsory licenses are only for emergencies such as HIV epidemics. This is also false. There's an important 2001 Doha Public Health Declaration, and one of the clarifications in that is that every member state has the right to grant compulsory licenses and decide the grounds. It doesn't have to be only for an emergency, and HIV is not the only emergency. So a country like Thailand could issue a compulsory license even if HIV is not an emergency, or even if it considered cancer an important issue without there being an emergency. Just the fact that its citizens can't afford a necessary drug is enough. Now, the last clarification is that compulsory licenses are not only for the poorest countries. A middle income country like Thailand is not prohibited from using a compulsory license. There's nothing in TRIPS that prohibits this, and again, the 2001 Doha Public Health Declaration says that each member has a right to grant it. It does not say it's limited to only the poorest countries. Now, the exception in terms of when you can make drugs under a compulsory license for export is for the poorest countries, but in terms of countries wanting to make drugs under a compulsory license for its own domestic needs, that applies to all countries. Now, just to recap on the prior negotiation requirement. Um, there is a prior negotiation requirement in general before you issue a compulsory license. In other words, before you issue it, you should generally first ask the patent owner and try to negotiate on reasonable terms. But there is an important waiver of this requirement in three instances. The first is national emergency, the second is in other cases of extreme emergency, and the third is for cases of public non-commercial use. Now, importantly, the Doha Public Health Declaration has stated that every country gets to decide for itself what is a national emergency, and that HIV/AIDS could be considered one of a number of national emergencies, but it's not limited. This is just as an example. In addition, a common misunderstanding is that this waiver may also exist for public non-commercial use. You don't have to have a national emergency. So, for example, when Thailand made drugs under a compulsory license for cancer, drugs that its citizens could not afford, that is okay even if there's not a national emergency, if those drugs are made under public non-commercial use, in other words, not for private profit. Now, there isn't really a clear definition of public non-commercial use, but considering there is not a clear definition, that seems like there should be current flexibility for each country to define it, just like countries can define what new means. Now, there have been some important cases of compulsory licenses in recent years. As I've mentioned, Thailand issued a number of compulsory licenses for antiretrovirals, Plavix, and cancer drugs. At the time, these were highly controversial. Thailand got a lot of political flack, lots of negative editorials. Like I said, Abbott had issued pressure, so did the US and EU, and Thailand even knew that it was going to face political pressure and issued a 60-page document trying to thwart in advance public controversy. More recently, India in 2012 issued its first compulsory license on a cancer drug under the highly controversial compulsory license provision that says that within a certain time frame you can issue a license if the drug is not available at a reasonably affordable price. In this case, Bayer, the patent owner, was providing the drug at over $5,000 a month for a 1 month supply, whereas the average annual income in India was a mere $1,300 a year. So under the new compulsory license, it will be sold at 3% of Bayer's original price, and Bayer will be paid a 6% royalty. This is currently under review, but it's still notable that this was issued under this highly controversial provision, and so far there has been less political backlash than for Thailand. Also, in most recently, October 2012, Indonesia issued a number of licenses on antiretrovirals to very little fanfare. Um, uh, to, to the contrary, there has been some cases recently where companies have been slashing prices in India, Indonesia, and even in the US in, I guess, response to public controversy about drugs that are too expensive. So perhaps compulsory licenses will become less controversial than they have been in recent times. That only remains to be seen. Now, moving beyond TRIPS, there is a trend for what's called TRIPS Plus agreements that require more than TRIPS does. These are generally agreements that are negotiated by the US or EU, bilateral and multilateral agreements, where basically the agreements aim to require more than TRIPS does. So some of these agreements require that new uses must be patented, and maybe also define that new includes drugs that are only marginally new. and not more efficacious. In other words, precluding the type of flexibility that India has had. Some of them require longer patent terms, limit compulsory licenses, and limit challenges to patentability. In other words, all the flexibilities that India has exercised. Also, some of them require more than just patent protection, um, something I call beyond patent protection. So that has to do with the fact that TRIPS requires that data be protected, but doesn't exactly explain how. So this is something that countries sometimes mandate that for a certain period of years, um, information that was first provided to regulatory authorities to show that a drug is safe and efficacious cannot be relied by a generic manufacturer for a certain number of years. But there are other procedures beyond this that have been coming into TRIPS Plus agreements, such as price controls and also increased consumer information that companies are permitted to give to consumers even without advertising. Now, this is the last slide, and I am saying that the conclusion is to be determined because it is to be determined. Although we have TRIPS and TRIPS Plus, there's a lot of on the ground advocacy by NGOs and consumer groups and also countries themselves that are pushing back on some of the efforts of patent owners and some countries. So it remains to be seen what will happen, but hopefully this provided some overview of some of the key issues under TRIPS and beyond. For a more detailed discussion, I have other information on SSRN and also a book called Access to Medicine in the Global Economy, International Agreements on Patents and Related Rights, including an entire chapter on flexibilities under TRIPS, such as what India has done. I hope that's helpful, and I welcome any questions you have you can send them to my email at cho@luc.edu. Thanks very much for your attention. Goodbye.